Most Americans grow up hearing that Brown versus Board of Education ended segregation in schools. That statement is true, but it barely scratches the surface. What this case really did was redefine what equality means under the Constitution and clarify the Supreme Court's role when long-standing laws no longer match lived reality. Brown was not just about classrooms. It was about whether the Constitution protects people in theory or in practice. By the early 1950s, segregation in public education was deeply entrenched across much of the United States. In some states, segregation was explicit and enforced by law. In others, it existed through policy, custom, and geography. The legal foundation for all of it rested on one Supreme Court decision from 1896, Plessy versus Ferguson. That case upheld segregation under the doctrine of separate but equal, a phrase that would shape American life for more than half a century. In reality, separate was never equal. Schools for black children were routinely underfunded, overcrowded, and poorly equipped. Teachers were paid less. Buildings were older. Textbooks were outdated or discarded hand-me-downs from white schools. These conditions were not hidden. They were known, documented, and largely accepted by the legal system. Courts focused on surface comparisons rather than outcomes, avoiding the deeper question of whether separation itself was a constitutional harm. The NAACP understood that challenging segregation school by school would never be enough. Instead, they pursued a long-term legal strategy designed to expose the inherent inequality built into segregation itself. Thurgood Marshall and his team deliberately brought cases where the disparities were obvious, forcing courts to confront the gap between constitutional promises and social reality. One of those cases arose in Topeka, Kansas, a city often described as moderate compared to the Deep South. Oliver Brown's daughter, Linda, was denied admission to a white elementary school close to her home and required to attend a segregated black school farther away. This was not an isolated inconvenience. It reflected a system where race, not geography or quality, determined opportunity. Brown was only one of several cases consolidated before the Supreme Court. Others came from South Carolina, Virginia, Delaware, and Washington, D.C. Each case told a similar story. Children denied equal educational opportunity because of race, justified by laws claiming equality while delivering inequality. By combining these cases, the court acknowledged that this was not a regional issue. It was a national constitutional question. The legal issue before the court was precise but profound. Did state-sponsored segregation in public education violate the Equal Protection Clause of the 14th Amendment? That amendment promises equal protection of the laws to every person. The justices were forced to ask whether separation by race could ever be equal, even if physical resources appeared comparable. What made Brown different from earlier cases was the court's willingness to consider the real-world effects of segregation. The justices examined social science evidence, including research showing that segregation harmed black children's psychological development and sense of self-worth. This evidence mattered because it reframed equality as lived experience, not just formal policy. When Chief Justice Earl Warren delivered the decision in 1954, the court spoke with one voice. The ruling was unanimous. The court declared that separate educational facilities are inherently unequal. That single sentence dismantled the legal foundation of segregation in public education. Plessy versus Ferguson was not explicitly overturned in full, but its core logic was rejected where education was concerned. For lawyers and legal scholars, this moment is critical. Brown marked a shift in constitutional interpretation. The court moved away from rigid formalism and acknowledged that the Constitution must be interpreted in light of social realities. Equality was no longer measured only by intent or structure, but by effect. That approach continues to influence equal protection analysis today. However, Brown did not order immediate integration. That delay mattered. In the follow-up decision, often called Brown 2, the court instructed states to desegregate with all deliberate speed. Those words were intentionally flexible, and many states used them to slow or resist compliance. Massive resistance campaigns followed. Some school districts closed public schools entirely rather than integrate. Despite resistance, Brown reshaped the legal landscape. It provided the constitutional backbone for later civil rights victories, including challenges to segregation in transportation, housing, and public accommodations. It also signaled that the Supreme Court was willing to confront entrenched systems when they conflicted with constitutional principles. The relevance of Brown did not end in the 1950s. Courts still cite it when evaluating equal protection claims today. Debates over school funding, district zoning, and educational access all trace back to the principles articulated in Brown. Even when segregation is no longer written into law, its effects persist through policy and structure. Modern discussions about education inequality, including disparities tied to income, geography, and race, still raise questions Brown forced the nation to confront. The case reminds Americans that equality cannot be symbolic. It must be functional. It must be measurable in outcomes, not just promises. In recent decades, Supreme Court decisions have narrowed and expanded Brown's reach in different contexts. Some rulings limit the use of race-conscious remedies, while others reaffirm the importance of equal access to education. These debates show that Brown is not frozen in history. It is a living precedent, continuously interpreted and contested. Even in contemporary political discourse, Brown remains relevant. Presidents from both parties reference it when discussing civil rights and education. Under the Trump administration, for example, debates over federal involvement in education, states' rights, and the role of the courts revived long-standing tensions between local control and constitutional guarantees. Brown stands as a reminder that when local systems fail to protect constitutional rights, federal courts have both the authority and the responsibility to act. For legal professionals, Brown is essential reading not because it offers simple answers, but because it demonstrates how constitutional law evolves. It shows how courts respond when doctrine collides with injustice, and how legal strategy, evidence, and timing can converge to produce lasting change. If you're still watching, ask yourself this: if Brown were argued today, what evidence would matter most? Test scores? Funding gaps? Access to technology? Dropout rates? These are not abstract questions. They are the modern echoes of a case decided 70 years ago. And if this case made you rethink how the Constitution operates in real life, say so in the comments. Lawyers, students, educators, and everyday citizens see Brown differently, and those perspectives matter. If you want more Supreme Court cases explained with this level of depth and realism, follow the channel. The next case will push this conversation even further. After Brown versus Board of Education was decided, the law changed faster than society was willing to follow. That gap between legal victory and real-world implementation is where the deeper lessons of Brown live. For anyone who studies constitutional law, civil rights, or public policy, Brown is not just a case about what the court said. It's a case about what happens when the court speaks and the country hesitates. The immediate aftermath exposed a truth lawyers know well. A Supreme Court ruling does not enforce itself. States were required to dismantle segregated school systems, but many responded with delay, evasion, or outright defiance. Legislatures passed laws designed to preserve segregation indirectly. School boards redrew attendance zones. Governors publicly challenged federal authority. Courts were forced to supervise compliance district by district, often for decades. This period reshaped the role of federal courts. Judges were no longer simply resolving disputes after the fact. They became active overseers, issuing injunctions, approving desegregation plans, and monitoring school districts over time. Brown expanded the concept of judicial power from interpretation to enforcement, especially when constitutional violations were structural rather than isolated. For lawyers, this evolution matters. Brown laid the groundwork for institutional reform litigation, the kind that targets systems instead of individuals. Prisons, hospitals, housing authorities, and police departments would later face similar legal scrutiny. The idea that courts could mandate change across an entire public institution traces directly back to Brown's enforcement struggles. But Brown also revealed the limits of the law. Even as formal segregation declined, new patterns emerged. White flight reshaped cities. Suburbanization altered school demographics. Property tax-based funding entrenched inequality in a different form. Schools were no longer segregated by statute, but by zip code. The law had changed, but inequality adapted. This raises a hard question Brown never fully answered. What does equal protection require when discrimination is no longer explicit? Courts have wrestled with this for decades. Some decisions have treated unequal outcomes as constitutionally irrelevant unless discriminatory intent can be proven. Others have recognized that systems built on past discrimination continue to produce unequal results, even without overt bias. That tension defines modern equal protection law. Brown stands at the center of it. The case did not promise identical outcomes. It promised equal access and equal dignity under the law. Yet defining where access ends and outcome begins remains one of the most contested areas in constitutional jurisprudence. In education, this debate plays out in funding lawsuits, standardized testing, and admissions policies. Plaintiffs often point to stark disparities in resources and achievement. Defendants argue that these differences reflect socioeconomic factors beyond the Constitution's reach. Courts must decide how far Brown's logic extends into a world where inequality is real but causation is complex. The Supreme Court itself has not been consistent. Some rulings invoke Brown expansively, emphasizing the harm of segregation and exclusion. Others interpret it narrowly, cautioning against race-conscious remedies and emphasizing formal neutrality. This inconsistency reflects broader ideological divides about the court's role in addressing social inequality. Political context matters too. Judicial appointments shape how Brown is understood and applied. Conservative justices often stress colorblindness, arguing that government should not classify by race at all. Liberal justices are more likely to emphasize historical context and ongoing disparities. Brown is cited by both sides, often to support opposing conclusions. That's not accidental. Brown is powerful precisely because it is principled rather than prescriptive. It established a constitutional value, equality in education, without dictating every method for achieving it. That flexibility allows the case to endure, but it also invites conflict over its meaning. In today's legal climate, Brown is frequently invoked in debates about affirmative action, school choice, and federal oversight of education. Critics argue that some modern policies depart from Brown's promise of equal treatment. Supporters counter that ignoring race entirely allows inequality to persist unchecked. The case continues to frame these arguments even when the outcomes diverge. From a practical standpoint, Brown teaches lawyers how precedent functions over time. Landmark cases do not settle debates permanently. They shift the terrain. They create new questions while resolving old ones. Brown did not end educational inequality. It forced the nation to confront it openly and legally. For law students and practitioners, this is a crucial takeaway. Constitutional law is not static. It evolves through interpretation, enforcement, resistance, and adaptation. Brown shows how legal change interacts with political will, public opinion, and institutional inertia. There's also a lesson here about strategy. The NAACP did not stumble into Brown. It planned for it over decades. It selected plaintiffs carefully. It built evidentiary records. It waited for the right moment and the right court. That level of strategic patience is rare, but it's instructive for anyone pursuing systemic change through litigation. Brown also reminds us that progress is rarely linear. Gains can stall. Advances can be narrowed. Rights recognized in one era can be questioned in another. The durability of a decision depends not just on its reasoning, but on how future courts and citizens defend its principles. If you're a lawyer watching this, think about how often Brown is cited without being fully understood. If you're a student, consider how this case shapes doctrines you may take for granted. And if you're not in the legal field, ask yourself whether equality today looks like the promise Brown envisioned. Because here's the uncomfortable truth: many of the structural challenges Brown confronted still exist, just under different names. And whether the law can, or should, address them remains an open question. If this analysis pushed you to think beyond the textbook version of Brown, drop your perspective in the comments. Legal minds disagree on where the case should lead us next, and those debates matter. Stay with the channel, because the final part will confront the hardest question of all: what Brown means for America now, not as history, but as living law. Brown versus Board of Education didn't just reshape classrooms, it reshaped America's understanding of constitutional responsibility. The decision created a legal precedent. When the government permits inequality under law, the courts can step in to enforce the Constitution. For lawyers, policymakers, and citizens alike, this principle remains as relevant today as it was 70 years ago. Consider federal oversight of schools in recent decades. Courts still rely on Brown when assessing whether districts have addressed disparities in funding, staffing, and facilities. If a district fails to provide comparable opportunities, the legacy of Brown gives plaintiffs a legal pathway to challenge that failure. It is not merely historical, it is active law in action. The case also illustrates how the judiciary interacts with political power. Chief Justice Warren understood that the court's moral authority mattered as much as its legal authority. The unanimous ruling sent a message. The court speaks as the guardian of constitutional guarantees, even when society resists. That principle echoes in today's political climate. During the Trump administration, debates over federal education funding, charter schools, and civil rights enforcement highlighted the tension between executive authority, state discretion, and judicial oversight. Brown remains a reference point in discussions about whether federal intervention is justified when states fail to provide equal opportunity. For students of law, Brown provides a model in legal reasoning. The court considered not only statutes but the real-world effects of those statutes. Psychological research, social evidence, and the lived experiences of children informed the decision. Modern litigation often follows this pattern. Lawyers crafting equal protection arguments now rely on empirical evidence, data, expert reports, and community impact studies, because Brown proved that outcomes matter, not just the language of a law. Courts are more likely to be persuaded when cases demonstrate tangible harm, just as Linda Brown's experience illustrated in 1954. Yet the case also teaches a hard lesson. Legal victories require vigilance. After Brown, integration proceeded unevenly, sometimes reluctantly. Lawyers, civil rights organizations, and parents had to push districts, monitor compliance, and litigate repeatedly. This is a practical lesson for anyone interested in systemic change. Winning in court is one step, ensuring implementation is another. The mechanics of law, enforcement, and political will must align, or the promise of equality remains theoretical. Today, debates about school funding and racial disparities continue. Nationwide, schools in low-income and predominantly minority neighborhoods often receive less funding per student than wealthier, predominantly white districts. Infrastructure, technology, teacher quality, and extracurricular opportunities vary dramatically. Brown did not eliminate these inequalities, it provided the framework for challenging them. Lawyers and advocates use this precedent to argue that constitutional guarantees demand action, not just words. This is the living impact of a case decided decades ago. Brown's relevance extends beyond education. Its principles inform cases on voting rights, housing, employment discrimination, and healthcare access. The concept is simple: separate or unequal treatment under law can violate constitutional protections. When citizens encounter structural inequities today, Brown provides both historical and legal authority to challenge them. It reminds Americans that the Constitution is not static, it evolves as courts interpret it in light of society's realities. Consider, for example, how the case shapes discussions about school choice and charter schools. Critics argue that some programs exacerbate segregation by income or race. Supporters counter that parental choice empowers families in historically underserved communities. Brown functions as a lens. Any policy that maintains or increases inequality can be scrutinized under the principle that separate is inherently unequal. For lawyers, this is a crucial argument. For parents and educators, it's a moral and practical benchmark. Brown also demonstrates the enduring power of strategy and timing in law. The NAACP meticulously built cases across multiple states, chose plaintiffs whose situations highlighted the inherent injustice, and presented a compelling evidentiary record. Lawyers today can learn from this approach. Systemic change requires careful planning, evidence-based arguments, and patience. Quick wins are rare. Sustained legal advocacy often drives meaningful reform. Even politically, Brown has lessons. Courts are not insulated from society. Decisions must consider both law and perception. Chief Justice Warren deliberately sought unanimity to send a message of national unity. Today, when controversial rulings are announced, similar concerns about legitimacy, public perception, and enforcement shape judicial strategy. Lawyers, students, and policymakers should understand that legal reasoning operates in tandem with societal context. This is where viewers can reflect personally. How do we measure equality in America today? Do opportunities vary based on zip code, race, or income? Brown forces Americans to confront these questions. By exploring real-life examples, from underfunded schools to gaps in educational achievement, viewers can connect historical precedent to modern reality. The case encourages civic engagement. Voting, advocacy, and legal participation matter because these principles are not abstract. They affect everyday life. If you are watching this, think about the broader implications. The next time a legal debate over education, civil rights, or federal authority arises, remember that the court's authority to act derives from cases like Brown. Ordinary citizens, parents, lawyers, and activists continue to shape how the decision is applied. Your voice matters because this is living law, not history frozen on a page. So here's a practical takeaway. When you see disparities in your community, ask yourself if they align with the principles Brown established. Are all children receiving equal access, resources, and dignity? If not, the law provides tools to challenge injustice. Brown shows that constitutional protection is not symbolic. It is enforceable. Legal professionals, policymakers, and everyday citizens share responsibility for ensuring that promise is realized. Before we close, consider one final angle. Brown versus Board of Education exemplifies the intersection of law, society, and policy. It teaches patience, strategy, and vigilance. It underscores the power of empirical evidence in legal arguments. It reminds us that even landmark decisions require continuous advocacy to produce lasting impact. And, importantly, it signals that the Constitution, through judicial oversight, can correct injustices even when political leadership or local authorities resist. If this video gave you new insights, here's what to do next. Subscribe to follow this series on Supreme Court cases that continue to shape America today. Comment your perspective. How do you see Brown's principles reflected or ignored in your local schools? Share this video with friends, colleagues, or students to spark discussion. Every conversation reinforces understanding, engagement, and the living legacy of the Constitution. Brown versus Board of Education is not just history. It is the foundation of modern equal protection law, a roadmap for legal advocacy, and a mirror reflecting the challenges of creating a truly just society. Understanding it equips viewers, lawyers, and citizens alike to navigate today's legal landscape, confront inequality, and engage meaningfully with the rights guaranteed to every American. Remember, equality under the law is more than a principle. It's a practice, an ongoing responsibility, and a challenge to each generation. Brown provides the lens, the legal reasoning, and the historical weight to approach that challenge with knowledge, insight, and authority.